Sometimes a huge, multi-million-dollar fight can be lost because of one tiny mistake. We're talking about a full-blown homeowners' revolt against their HOA, a battle for control of their neighborhood that was completely derailed by a single, accidental piece of paper.
So, what was this all about? Well, at its heart, it was about frustration. Keith Jackson, the homeowner who was leading this whole effort, really put it best. He and his neighbors felt like their board was making these huge decisions behind closed doors, and they were really starting to see the financial fallout.
And to really get why they were so angry, you've got to follow the money. At the beginning of the year, their community had a really healthy reserve fund. We're talking $3.4 million, a nice cushion for the neighborhood.
But then, by the end of that same year, that reserve was projected to crater, to fall below $1 million. I mean, think about that. A drop of over $2 million in just 1 year, with pretty much no explanation. For a lot of residents, that was the final straw.
So, the homeowners decided they had to do something. They started gathering signatures to get 4 board members removed. But their campaign, this whole effort to get some accountability, it started with a critical and, as it turns out, a totally fatal mistake.
Check this out. This whole thing went south in just about 2 weeks. On July 12th, a friend of the organizer makes an honest mistake. They turn in the recall petition early. It only has 214 signatures, not enough. 6 days later, the HOA, of course, rejects it. So the homeowners think, okay, no big deal, we'll just fix it. The very next day, they submit the completed petition with over 250 signatures. But it was too late. On July 25th, the HOA rejected it again, this time because of a legal technicality.
And just like that, the fight wasn't about the money or transparency anymore. It moved from the neighborhood to the courtroom, and the entire case came down to 2 completely different ways of reading the exact same state law.
So here were the 2 arguments. The homeowner said, look, that first submission on July 12th wasn't a valid petition. It didn't have enough signatures, so it shouldn't count as our official attempt. But the HOA, they argued the law is brutally simple. You get 1 shot. The second that first petition was handed in, that was it. Their 1 attempt was used up, complete or not.
And this is the piece of Arizona law that the entire thing hinged on. People call it the one-shot rule. Now, it was originally designed to stop board members from being endlessly harassed with recall after recall, but in this case, it became the HOA's trump card.
So, who do you think was right? Should the spirit of the law, letting residents have their voice heard, win the day? Or is the procedure absolute, even if it's based on a simple, honest mistake? Well, an administrative law judge had to make that exact call.
After hearing both sides, the judge came back with a decision. And it didn't come down to fairness or what the homeowners intended to do. Nope, it came down to the very specific, literal words written in the law. Okay, so first, the judge looked at when the law actually kicks in, and the statute says the clock starts ticking on receipt of a petition. On July 12th, the board physically received a petition. That simple act, just receiving the papers, was enough to trigger the rule.
And here it is. This is the killer detail. The judge pointed out that the law never says the petition has to be complete or valid for that one-shot rule to apply. It just has to be submitted. That accidental, incomplete submission on July 12th was, legally speaking, the one and only shot they were ever going to get.
And this, right here, this is the nail in the coffin, straight from the law itself. Just listen to the wording. Shall not be submitted more than once. See what's missing? It doesn't say a valid petition, it doesn't say a complete petition, and because the law is silent on that, it means any submission, even a mistaken one, counts as your one shot.
So the final verdict was in, and it was crushing for the homeowners. The HOA was right. The judge dismissed the case, ruling that the second, correct petition was totally invalid because their one shot had already been fired by mistake back on July 12th.
So okay, that's one really painful story about one neighborhood. But what's the bigger lesson here? Well, this case is a huge wake-up call for anyone living in an HOA, and it really highlights how these kinds of fights are often won and lost.
The number one takeaway is brutal, and it's simple. In these kinds of legal fights, procedure is king. It doesn't matter how right you think you are or how many of your neighbors agree with you. One single mistake, like turning in a form a week early, can make your entire effort completely worthless in the eyes of the law. Your good intentions just don't matter as much as the literal text on the page.
And all of this leaves us with a really fundamental question, doesn't it? This one-shot rule was put in place to protect volunteer board members from being constantly harassed. But as we just saw, it can also shield them from accountability because of a simple, honest mistake. So you have to wonder, where's the line between protecting a board and preventing residents from ever being heard?